Good morning. Charlie Jimerson here from Jimerson Cobb, and I'm going to speak to you today about collections law. Just by way of introduction, I'm an attorney at the law firm of Jimerson Cobb, the founding shareholder. We're a business litigation law firm located in Jacksonville, Florida. I would say we have a statewide and regional practice, but we're headquartered here in Jacksonville. We have around 7 attorneys at present time, and most of our focus is on commercial litigation with a particular specialty in construction law and financial services. Collections law is very much part of what we do and how we got our start. And I'm going to speak to you today regarding several issues pertaining to collections law, so that hopefully you'll come away with a greater understanding of some pitfalls and potential practice points. Just by way of my biography, I've served as litigation counsel and the accounts receivable collection arm for many different ranges of businesses, whether it be nationwide plant nursery, automotive dealership conglomerates, nationwide medical supply companies, multiple construction materials suppliers, architectural firms, IT firms, marketing, PR, and accounting firms, private equity lenders, regional and community banks, real estate development companies, construction companies of all sorts, whether it be general contractors, subcontractors, or suppliers, and many different condominium and homeowners associations. So I would say that my background in collections is wide varying and might have some angles of which perhaps you might come away from this learning something. So this presentation will be divided up into 4 parts. The first part will be pertaining to locating assets before and after a judgment. The second part will be collection methods that I've found that have worked through experience. The third part will be bankruptcy implications, and the last part will just be some FDCPA, Fair Debt Collection Practices Act, tips and legal issues. So moving on into our first slide. Collections law, one of the first keys to collections law is getting your judgment. And so the scope of our presentation today won't be centered around the nuances of what it takes to push a case through in civil litigation. Rather, it'll be finding assets and collecting on the judgment. Getting the judgment is really the primary goal. It's the most important thing that you have to do. It's certainly the condition precedent to go enforcing the judgment and having the rights to be able to collect on those assets that you found. So that the key thing is going through and getting the judgment. But without an understanding of what assets exist, your judgment's not worth the paper that it's written on. So the following sections will cover some of the available methods to locate assets. These methods can be used, some of them can be used by anyone, and other methods will require legal assistance, whether it be through attorneys, sometimes even local or licensed private investigators, or even police intervention can be utilized in the collection process. Many of the processes that we'll talk about today can be used at any time, even without a lawsuit pending. Some of them may even be used by the client or at the onset of the relationship with a potential debtor. Other processes will require judicial intervention in the court system in order to accomplish your goal. So let's talk about some pre-suit means to locate assets. I think pre-suit is a way that you can really, when the file comes to you as a lawyer, there are certain things that I've had communications before the file is placed with my client to give them an understanding of what I'm looking for, what I want, how I want the information synthesized, so that I can work through the file quickly and efficiently and cheaply for the client. A lot of the debtor information is going to be included in the client's underlying file. So whether it be, let's just take a material supplier of some sorts. Most material suppliers supply goods based on a credit application. The particular customer will come in, They'll fill out the application, which has all the terms and conditions of supplying, and hopefully in doing so, they'll gather a great deal of personal information about the customer, their business location, their points of contact, their accounts payable points of contact, their trade references, their banking information, any type of additional collateral information that the trade creditor may require. So your client's file is going to be a great source of information for you to sift through and locate assets. At matter's inception, you want to understand that there's an end goal. So if you're going through and getting your judgment, of course, going through and getting your judgment is part of the process for the client in order to be able to write the matter off, and certainly a consideration when you're reserving bad debt and resolving bad debt on a balance sheet. But for a lawyer, you really are doing your client a disservice, in my opinion, if you do not take some steps at onset to understand who you're dealing with and whether there's a pot of gold there. So the client's own file and their own internal contract documents are going to be a really useful source of information. A lot of times, most of my clients will provide me with some type of credit report that they've already run. Maybe it's a Equifax or a DMB or some other type of report of that nature that has all the articulations of known credit demerits or references to assets, things like that. Clients will often provide, as part of their workouts with the delinquent debtor, they'll be require them to provide financial information, such as a financial statement or perhaps some bank statements, information that shows the current financial position of the defendant. Trade references will also be a helpful helpful nugget of information that you can glean from the client's file. If you're trying to understand if this particular defendant is is delinquent with a lot of other creditors, picking up the phone and calling those trade references that were listed on the credit app is really helpful in determining whether you're dealing with an isolated issue or a widespread problem with respect to delinquencies. Very often with an accounts receivable collection, there will be a course of dealing between the debtor and the creditor such that at some point in time materials or goods have been purchased and they've been paid for. If that happens, you're going to inquire into whether or not there's cash checks, perhaps there's credit cards that have worked that have been on file, perhaps there's a whole litany of banking information or financial information which you can then utilize after you obtained your judgment. The only other thing that and we'll talk a little bit more about ways to locate assets in the public records shortly, but I encourage you to have a personal conversation with your client that places the file. A lot of times it's going to be someone in the receivables department, credit manager, but the credit manager may know some great detailed information about the defendant, but very often the salesperson is going to be the one most knowledgeable with the file. They're the relationship conduit. They're the person who is going to have the most personal experience with the debtor. So it behooves you to pick up the phone and just have a quick conversation with the sales folks. Let them get an understanding of whether they know if the debtor's solvent. Is the debtor in business? What's the problem? Why didn't they pay? Are you looking at any type of defenses? Maybe there was some non-conforming goods that were provided. Maybe the goods weren't provided at all and the accounting invoicing is messed up. You want to have those type of conversations with your clients before you willy-nilly start ripping out demand letters and filing lawsuits. It could be quite embarrassing to file suit on an accounts receivable if there's no underlying basis to do so. So moving on to locating assets pre-suit utilizing public records. Once you know what the debtor's assets are, you know what avenues to take in order to recover that debt. And again, the first methods that you should take should be this informal process. of gathering information. And I've listed a couple items on our slide here which you could utilize to gather information, which I regularly utilize. One of the first things that I'll do, which kind of consolidates a lot of these public records reports, is run a paid search through a program that we have as lawyers through LexisNexis. But there are also other credit reporting agencies, Dun & Bradstreet, Experian, Equifax, TransUnion, etc., which consolidate all of the debtor's information, might provide credit history, might provide references to other creditors, might provide lien holders, an idea of what judgments are existing out there, if there's any IRS or other tax liens, and an idea of what known filings there are as assets, be it motor vehicle records, real estate, or if there's any UCC regarding any significant inventory or personal property. But notwithstanding a consolidated report on those items, there are independent agencies which have this information online, both the national, regional, national and state and local levels, motor vehicle records being one of them. You might want to log on to the respective DMV, Department of Motor Vehicles website from your state and peruse through that online registry to see if there are any known vehicles that you'll be able to execute on or seize if a judgment is actually obtained. Through that resource, you can find out what vehicles exist. Oftentimes, you'll be able to see if there's a lien associated with that, and thus if you have to satisfy any prior perfected creditors at a foreclosure sale or a execution sale. So the motor vehicle registry is going to be helpful for that respect. It's also going to tell you if there's any, sometimes trailers have to be registered. Of course, depends on your state laws, but boats, things like that. Public records with respect to real estate are also very helpful. No matter what the case, before I file suit, I'm going to hop online and I'm going to check the public records in the county in which I'm filing the lawsuit, because I'm going to see how many judgments have been perfected prior to this. I'm going to see what real property exists there, because once you get your judgment, you're going to want to perfect that judgment, record it in the county of record, and it will serve as a lien on the real property, such that when they liquidate that real property or dispose of it, your judgment will have a good chance of being satisfied. Or as well as give you a particular resource by which to execute on your judgment if it's unencumbered and if it's cost effective to do so. So the way to look this up is typically through just doing a quick Google search for your county, for the clerk of court, or the property appraiser's website. The clerk of court is going to give you a little bit different information. It's going to give you information regarding liens, mortgages, judgments, etc. Property appraiser's website, you can typically just look up addresses and individuals and get more details regarding the specific parcel. Additionally, there are some other things that you can look at in the public records which can help you locate assets pre-suit. Things, just commonsensical things, such as telephone directories, voter registration websites, city or state business license filings, those type of things. Business license filings, for example, that would be something that you could give an idea of whether there's any corporate interest that you would be able to seize, whether there's an ongoing stream of revenue that's still available there for perhaps you to garnish wages. You also want to probably take a look at and ascertain through the Secretary of State's website whether the entity is an active entity, whether or not it's been filing its annual reports, or whether it's been administratively dissolved. And if has been administratively dissolved, do you have remedies then to go against the individual guarantors or the stakeholders, members, shareholders, etc., for improperly winding down the company, or perhaps purchasing the goods or services when the company was dissolved or inactive. There's liability in several states. Many states, I haven't done a nationwide survey, but if individuals are purchasing goods representing it to be a corporate transaction and there's no affiliated corporation, I would be hard-pressed to find many theories of law that would shield those individuals from individual liability. So that's something for you to look at. One other thing, there's many different items. Really, with respect to the public records, you're at the whims of the power of Google and your own creativity. Looking through SEC filings, 10Ks, 10Qs, there's going to be great sources if it's a publicly traded publicly traded company. That's going to be a great source for what information is available. So I encourage you to exhaust your capabilities in utilizing your vehicle, real estate, personal property, and public records resources online, and have a good roadmap before you file suit as to what you're going to do to collect that suit once you do obtain that judgment. So continuing on with informal methods of locating assets, we talked briefly about pay websites such as LexisNexis and Westlaw, but another item that's really only become of relevance in the past 5-10 years is websites and social media. Many debtors will boast about themselves, their businesses, their possessions, their accomplishments in online forums and social media. Any particular debtor may have a website that has details, information that you want to know, and sometimes maybe a lot more than you want to know. But nonetheless, using your own creativity and understanding what websites are available to gather this information, you should do some searches on these particular websites. Facebook, Instagram, Twitter, any perhaps dating sites, photo sharing sites, Shutterfly, even online advertisements. Those items are going to have little nuggets of personal information, nuggets that might pertain to refuting an exemption that they may claim as head of household down the line. Maybe there's information as to where they live. Maybe there's information as to a trip that they're going on. Maybe there's information as to, I don't know, maybe you'll be able to see personal assets in some of their pictures, a large TV, furniture, artwork, jewelry, things like that you could store in your memory bank, such that when you're sitting across from the debtor at a post-judgment deposition in aid of execution, you can whip out a Facebook photo and say, I see you're not wearing this Rolex today. Tell me where that's at. And all of a sudden, you've got them in a real precarious situation where they've either disposed of a Rolex, thus committing fraud and avoidance of a creditor, or they've got it and they're lying to you about it. You'd be surprised at some of the looks I've got from debtors when I whipped out information from their social media sites. I think that one of the other items that I would comment on is using private investigators. That's a fairly conventional method to gather information when you're at a loss and you have a non-responsive debtor. I've had a private investigator before do 3 days of dumpster diving and come up with more documents than I ever could have come up with chasing a deadbeat debtor down. It was very impressive to see that the work product that they provided. It's not often cheap, but it is an outside-of-the-box method of going about things if you have a mountain controversy in a case that merits that level of resources. So moving on, I'm going to move into the post-judgment side of locating assets. So we've talked about some pre-judgment things, and then we've kind of glossed over the litigating component, because I'm going to assume in a lot of the, well, I'm not going to assume in a lot of these, but I would tell you more often than not, on a garden variety accounts receivable collection, if they've gone radio silent with the client, and it's a trade debtor. I do a lot of construction work, so I represent a lot of construction material suppliers, and I represent national medical material suppliers, and a lot of the companies that come up in those fields can be fly-by-night companies. Thankfully, there's personal guarantees on a lot of them, but I would tell you that a lot of the lawsuits that we file we're just going to obtain a default judgment. So they're not going to appear, and I'm not going to necessarily exceed the scope of this presentation by telling you how to go about getting a judgment in a collections action, because that's really a litigation issue, and it just depends on your issues on a case-by-case basis. So let's say you've got your judgment. Now what do you do with it? Well, if a legal action's pending, you want to follow, obviously you follow the rules of civil procedure in your respective jurisdiction, but the rules of civil procedure allow for some great remedies for creditors to conduct discovery and aid of execution, including depositions, built-in statutory required fact information sheets, interrogatories, requests for productions, requests for admissions, and deposition and aid duces tecums. So I'm just going to go through a little bit of those vehicles, tell you how I've used them, how to use them, and exactly what you'll be able to get out of those particular items. So any deposition or any discovery that you're going to do post-judgment, it's solely for the purpose of pinning the debtor down on his or her its assets and liabilities. If the debtor fails to tell the truth or conveniently omits information, you certainly have the ability to use that information against the debtor in court, much like you would any other admission in litigation. A series of improper conduct in discovery could rise to some pretty grievous penalties imposed by the court system, in some cases even confinement in jail if there's repetitive noncompliance. So just going through a couple of items as I've listed them here. Fact information sheets. In Florida, where I practice, there is a Form 1977, and what I do is in our judgments, I built in the requirement that the debtor fill out the fact information sheet and reply to us within X amount of days, and that's all pursuant to the statute. Nationwide, I think that there's been a movement to incorporate these type of items that are automatically requiring defendants to provide information without forcing the creditor to pursue all of the information and spend more money. In practice, I haven't found that debtors are very responsive to providing these fact information sheets. You have to remember that I've litigated matters from $5,000 to $625 million matters. In these garden variety collections matters, you're not dealing with a lot of entities who are going to be publicly traded companies. Those type of matters where if you reduce those to a judgment, it's likely going to be a contested matter. It's likely going to be after a trial, and if it's a solvent entity, they're going to pay it right away, and you're not going to have to play the chase the money game. So you have to realize what kind of denominator we're dealing with when we're doing a lot of these collections law issues. You're going to have to go find the money and force them to be forthcoming as to what their net worth is and assets. So fact information sheets, they're a great vehicle and concept. Pragmatically, I don't find them to be very abided by. One thing that's important to note is that in utilizing fact information sheets, it does provide you with a quick way to get back in front of the court if the defendant has not complied with discovery. Fact information sheet is discovery. If you've sent the fact information sheet out and there's a court order that requires them to return it, well, by God, then you should turn right around and move the court to compel response, or for a finding of contempt for failing to abide by the court's order. Another item that you can do, and it just depends on the type of the case and with a level of responsiveness and your client's preferred method of going about things, but I have some standard requests for production and interrogatories and requests for admissions that when I get my judgment, it's really not much for me to whip those out and send them to the defendant. It's cumbersome on them, and it requires them to do a lot of legwork to respond to your request. And hopefully if they respond the way that I intend them to when I send those out, you'll have the roadmap for all of your collection activities, or you'll have enough data to make a determination that it's cost prohibitive to continue. In requesting documents, again, you use your imagination, but you're going to want to understand all of their financial relationships, all of their asset holdings, all of their personal property, the ongoing nature of income stream if it's an individual, all these type of questions if it's a company as well. If it's a company, you're going to want to understand all of the different creditors that your judgment may be subject to, and anything that any well of resources that you can tap into in collecting your judgment. So third-party subpoenas. I think it's important for me to touch on that because I don't feel that's used often by practitioners. I think it's a crafty way of going about things and collecting judgments, and it's a way that you can put little pressure points on the defendant to make them go after responsive. The most common type of subpoenas are ones which request contracts, correspondence, bank records, maybe accounting records, loan applications, real estate records, financial statements, investment documents, etc. Sending a subpoena to an accountant of a judgment debtor may provide tax returns that open the door to a whole slew of other information, as well as getting additional people to provide you resources and information if your defendant has gone non-responsive. So the next thing I'm going to touch on is the deposition in aid of execution. This is a powerful vehicle, and much like the debtors don't respond very well to written discovery, they try to play games with you often in depositions in aid of execution. And depositions in aid of execution are one of the first things that you probably should do and consider once you've obtained your judgment and you're trying to locate assets. They allow for quite a broad scope. The creditor is really permitted to inquire into all financial aspects of the debtor. Typically, these type of depositions and these inquiries are not permitted in the liability phase of the litigation, but when the creditor obtains the judgment, the game really changes, and the judgment debtor is required to disclose, if properly questioned, most anything pertaining to their assets, all assets owned, which could include future anticipated earnings, community property, etc. Let me tell you a little bit about the process, and then maybe I'll tell you a couple of instances where I've had some fun times at depositions. So in the process, you want to always do a subpoena duces tecum, and I typically do my duces tecums to have a production 10 days in advance of the deposition. The duces tecum component is a requirement it's a subpoena which requires the debtor to provide certain information that you've requested, be it documents or other records that they may have. I have a long laundry list of items that I regularly request in my duces tecums, but you're going to want to obtain those type of bank records or the asset records which support the testimony that they are or are not giving you. You're going to want to obtain probably at the deposition all of the personal information of the debtor. You're going to want to verify all the respective information that you have on file that you were able to accumulate in your prejudgment asset searches, and you're going to want to ascertain whether or not that's still accurate. Social Security, driver's license, addresses, things like that. And you're going to inquire, obviously, well beyond the scope of publicly known records. One of the things that I like to do is when I set someone down for a deposition, I'll ask them for their driver's license, and I'll compare that to the driver's license records that I've found. But in doing so, most of the time they have to reach into their wallet, and when they reach into their wallet, I'll ask them on the spot to inventory their whole wallet. You'd be surprised at the responses that gets and the information that you'll be able to get from that. You have to. There's some considerations in this when you're dealing with Social Security's and private financial data, because this is an on-the-record examination. So the way that you utilize this information, you'll have to be careful of and be considerate of confidentiality and privacy considerations. One thing you should also inquire into in post-judgment depositions in aid is family information, and you should get the spouse's name, the maiden name, whether there are any children or dependents applicable, their places of birth, their ages, dates of marriage, places of marriage, full history. You're going to want to things pertaining to the family, such that when exemption issues come up, if you've garnished down the road, you'll have enough information on hand, perhaps to dispute whether or not there's a availability of any head of household type of exemptions. Beyond that, you're going to really want to get a full history of debtors' employment, what they do, how they generate income, what their business holdings are, what partnership interests they have, any stocks they may have, insurance policies or annuities, whether there's self-employment income, whether there's assets held in any other state, whether there's creditor-protected assets, whether there's a will, whether there's a trust, whether the defendant has ever filed bankruptcy before, have they consulted with a bankruptcy attorney, whether they anticipate receiving an inheritance, how did they get there today, what car did they drive, ask them to pull out their cell phone, how do they pay their cell phone bills. Oh, so you're paying your cell phone bills, I see. So that means that you're paying one creditor and you're not paying my client this creditor. So now you're prioritizing creditors. Explain to me why. Why is paying your cell phone more important than paying my client? You want to probe them on those type of issues, because that's how you're going to get response. One thing you also probably should do, and what I regularly do, is if you find assets, frankly ask the debtor, are you willing to transfer that over to my client right now in satisfaction or partial satisfaction of the debt? You'd be surprised that a lot of the times they'll say yes, and they should say yes, because if they say no, good chance I'm going to go seize it as soon as that deposition's over with. Again, with respect to third-party depositions, not just subpoenas to gather information, it's allowable within the rules to depose third parties pertinent to the debt that's owed. This can be spouses, accountants, business partners, employers, maybe even prior attorneys. You want to think about these pressure points and these sources of information that will help you think outside of the box to collect your judgment, post-judgment. If the defendant does not appear, or does appear at the deposition and does not provide the documents, that's not a reason for you to stop the deposition. You still want to continue and gather as much information, but then enforce your subpoena to provide the documents after the fact. Inquire to the full scope and breadth that you're able to. If they fail to appear at the deposition, well, they've got bigger problems now. Now you're able to go, because you as an officer of the court, if you're an attorney viewing this, has issued a subpoena, and the subpoena has not been complied with, and now you've got a pipeline to go back to the court to ask the court for an order to show cause for why the defendant didn't comply with your subpoena from a court order, from a court-appointed officer, and why cause should be shown as to why writ of bodily attachment should not be deposed or should not be imposed. I've had many people jailed for failing to come to my depositions or respond to my subpoenas. It's not something the courts like doing, but in the face of continual non-compliance with subpoenas, courts will do it, and they'll do it gladly if you can show them that it's willful non-compliance. And then oftentimes there's purge provisions in your orders of writ of bodily attachment or show cause, which allow them to purge the incarceration order as long as they submit to a depot. But there's some practice points there that you can utilize where submitting to a depot without necessarily identifying when the depot is going to be, that allows some, we'll just say, scheduling leeway on the lawyer's side as to when they have to actually go and schedule that depot, and whether maybe going to the jailhouse and deposing him in the jailhouse is a necessary evil. So continuing on with just some post-judgment compliance issues, I think we've touched a lot on this slide as to good faith letters and motions to compel and motions for contempt. It's important just for you to know, whatever your respective jurisdiction, that those items and those avenues are available for you for non-compliance. So we're going to move into now part 2 pertaining to collecting the judgment methods that work. Let me get caught up on my presentation here. Okay. So the first thing that you're going to do is perfect the judgment. And perfect the judgment can mean a lot of different things in a lot of different jurisdictions. Perfecting the judgment normally means so you've got your judgment, you've got it stamped by the judge or signed by the judge, and you want to get it. What you want to do is get it recorded in the county of record. In order to get it recorded, you've got to get it certified. You've got to get a certified copy recorded, and a certified copy would serve as a lien against the real property of that defendant and the of that defendant and the county of record where you record the judgment. You'll also want to do that for any county that the defendant owns property. So for me, for example, I live in Jacksonville. I'm getting a judgment in Jacksonville, I'm recording it in Duval County. But if through my diligence before filing suit, I've been able to understand that the defendant lives in 5 other counties in Florida, well, I'm also contemporaneously going to record my judgment in all of those 5 counties. If I don't get my judgment recorded, it's first in time, first in right in terms of creditor priority, and putting the other creditors and the world on notice that your judgment exists. There's some perils and pitfalls there for lawyers who don't get their judgments recorded timely. Perfecting the judgment also entails recording it as a lien on personal property. In Florida, that means going to the Secretary of State, making the electronic submission, and recording your judgment with the Secretary of State, such that anybody who goes to the public records there is able to have notice that that judgment exists and it's prioritized as of the date of filing. First thing first, always perfect your judgment. Get in line, establish your place. The next thing you want to do is, utilizing all of that information you've gathered pre-judgment and maybe even post-judgment, you want to do a bank garnishment. If you've got, let's just say for round numbers, you've got a $50,000 judgment and you've got a solvent company who carries a month of operating expenses, if you can garnish them and satisfy your judgment in one quick event, I think that's the quickest, most efficient way of doing it. We'll go through these individually, but I think just itemizing methods that work: perfecting judgment, bank garnishments, wage garnishments, execution and levy on personal and real property, asking for surrenders of collateral, and then we'll talk through some settlement and forbearance situations. So let me touch on garnishment. Garnishment is a post-judgment remedy whereby you're taking swipe at in using a snapshot in time accounts or pools of funds. It's followed. There's a motion that has to be submitted. There is a writ that is issued. Sorry. There is a motion that is submitted, and there is a writ that is issued by the court. In Florida, it costs $188. I call it a $188 gamble. One of the challenges with garnishments are you don't know what is in the account. You don't know whether the defendant owes any account, whether the defendant has any money. We'll just use banks, for example, at a banking institution. So I say it's a $188 gamble. If I've got a judgment and I'm not aware of any banking institutions, but the way that the defendant has assets, but the way the banking world is moving these days, the number of banks are really dwindling. So there's 4 or 5 different big banks, and the majority of the citizens in our country have accounts at those. It might be worth taking the $188 gamble, garnishing a Wells Fargo, garnishing a BOA, garnishing a Regions, garnishing a BB&T, or whatever your respective regional lender may be, in the event that there's funds there to satisfy your judgment. So once the court issues the writ, you've got the writ of garnishment. You serve it on your entities that you're seeking to garnish, and that serves as a prompt to those garnishees to freeze those accounts, to freeze those assets right there at that point in time, and nothing comes or goes from them. Aside from being the nuisance of not being able to transact, you've now got a claim to that. Of course, the defendant can still dispute that claim by way of exemptions that they could claim, whether it be head of household or otherwise. But you've got a stake in that asset that you've frozen, and now the garnishee is required to respond and let you know exactly what's there, and the garnishee then requests the court to order them on how they're to dispose of it. Service of the writ makes the garnishee liable for all debts owed to the judgment debtor. And that means, for instance, in Florida, if you were to serve a garnishee and a garnishee didn't respond, well, the garnishee now is liable to the full extent that they had funds available at the time of garnishment and did not proffer those funds or did not alert you to those funds. It serves as a lien, and if the garnishee fails to respond, then they've basically failed to create that lien, and by operation of law, you'll be able to go back and create the lien after the fact. The important thing with garnishment is to pay particular notice of the, to be respectful of the notice period. There's very tight deadlines with draconian consequences if you fail to comply with the notice provisions. In Florida, for example, there's a certain time period where you have to get a notice to the defendant of their rights against the garnishment, their rights to dispute the garnishment by claiming exemptions. Additionally, once the garnishment is imposed, the lien exists, there's a notice of garnishment that must be rendered to the defendant. And it lets them know that their funds, hey defendant, your funds have been garnished. You got to do something about it. If not, it's coming to the creditor. There's really tight deadlines on those. There's pretty strict enforcement by the court system, so you want to be particularly mindful of notice requirements in your respective jurisdiction. With a garnishment, the garnishee is going to file an answer. It's like a separate lawsuit. It's plaintiff versus defendant versus garnishee. Garnishee answers and says, I have $50,000 on file, and I don't know what to do with it, court. You tell me. And then it's up for the parties to then litigate that and decide. If no exemptions are claimed, and there's a time period typically by statute as to when exemptions are going to be claimed, or when they must be claimed, then the exemptions are waived, and there's a final judgment period in which you can submit your final judgment, and a final judgment of garnishment will be provided. Have a Rubio moment here real quick. So wage garnishment. That's another very powerful mechanism that you can employ. Federal law does limit the amounts that can be withheld on a wage garnishment, either 25% of disposable earnings, and that's a defined term, or 30 times the minimum wage, whichever is less. Citation for that is 15 U.S.C. 1673. Presently, federal minimum wage is around $8 per hour, given what state you're in. Disposable earnings, of course, is a defined term. It generally means gross pay less whatever is required by law to be deducted, such as taxes, child support, IRS payment arrangements, other garnishments, things like that. Disposable earnings may be higher than the defendant's net pay, since voluntary deductions such as health, life and dental insurance, union dues, savings plans, IRA, and other retirement contributions are subject to garnishment. Usually this is done by a continuing writ issued to the employer. This requires periodic payments of a portion of salary. You want to do a continuing writ. That's the key there, is when you move the court, make sure it's a continuing writ. It's not just a writ of wage garnishment. You want it to be a repetitive one. Remember, you're not taking the snapshot in time with the wage garnish or with a typical garnishment. You're getting the continuing writ imposed. And it doesn't necessarily, a continuing writ doesn't always have to be limited to just wages. You should use that in any time when there's an ongoing stream of income or revenue. But it continues until satisfaction or a court order, and it's a powerful mechanism for collecting your judgments. Property execution. Catching up here with my slides. Okay, property execution. Again, the procedures vary state to state, county to county. You're going to need an original writ of execution, and that's something you're going to have to move the court for. You'll have to complete. You'll have to give specific and complete levy instructions to the sheriff. I advise you to just call the sheriff, call down to the sheriff's department, ask them who the point of contact is, who does their levies and executions, find out any nuances that they want you to require. Of course, there's a lot of departments from county to county. There may be an obscure way that they do things. It may not be commensurate with the law. It may be, who knows, but the point is you want to please the sheriff because they're going to be the ones who are executing it. Find out what their procedures are. Find out what costs are. Sometimes it can be very expensive. There can be significant deposits because remember, as a creditor, you're paying for the services here that the sheriff's department is providing. And there is a component to going down and there's a kind of a forceful component, so you do need a sheriff to execute this process. Aside from being part of the law, but there's some issues there that you can have some unfortunate confrontations with defendants. I'll just tell a quick story. So I was doing a household goods levy. It's actually sad. I shouldn't laugh, but it was a good victory moment. Thankfully, everything turned out okay. But I was doing household goods levy with the sheriff down in South Florida, and we were seizing a lot of goods of this very solvent guarantor. Should have paid the judgment already. I think he was just playing some games with my client and I. And there was about an 8-foot bear that was one of his prized hunting possessions that we went to seize. We grabbed, we were getting the bear, we're loading it onto the trucks, and the debtor unfortunately had a medical moment. I don't know if it was a panic attack, anxiety attack. It was such a prized possession that on the spot he stroked my client a check for well over 6 figures. So executions have power. They're a powerful tool. I think the nature of having a sheriff there with you executing on some on the property is a very powerful notion. I'll give you another story here too, since we're telling a couple of war stories. I once got a judgment against the bar waited till Friday night when the place was absolutely hopping, filled with people, and I showed up with the sheriff and executed on the inventory of the bar, which under those circumstances were the cash receipts at the door, cash receipts in the register, and all the liquor there. So now the bar owner had no liquor to sell to all of his patrons, and it was a complete loss of a night for us. We were able to also make arrangements at that time to have our judgment satisfied. It was partially satisfied with our efforts, and then we had arrangements for the rest of it so that we could keep the gentleman in business. I thought that those were pretty powerful tools when employed appropriately and strategically, could really help you collect. There are a couple other items that, just depending state by state, that you'll need to comply with the law. You got to show that there's the ownership of the asset that you're trying to seize. Got to make sure you have your judgment lien certificate recorded. You've got to have a creditor's affidavit, and that's jurisdiction by jurisdiction. But that is an item that you can utilize. So I'm going to go through, just briefly touch on head of family exemption. In Florida, there's a head of family exemption, and that's defined in 222.11, which precludes or limits garnishment on any natural person who is providing more than one half of the support for a child or dependent. This is a great rule in place. I think that we don't necessarily want to have creditors attacking people who are truly head of household and the only folks who are providing for their family. I don't know, sometimes there's some stretches in the way that it's actually imposed, but at any rate, it's a law, and you have to be aware of it and abide by it. The head of household exemption can be waived in contract. There's specific rules to that, at least in Florida, and that typically is a waiver outside of the normal terms of the contract, separate and apart from the contract. It's not something you can bury in the fine print. It has to be bold, and it has to be, separate, incognizable, clear, and unambiguous. Corporations cannot be exempt from garnishment, so they can't be head of household, and that's important for you to note. You'll win that hearing every time a corporation tries to do that. Another item to reference with exemptions is that exempt earnings deposited into financial institutions are exempt for 6 months. So even if you're able to take a swipe at a bank account, they're able to claw back at least 6 months of exempt earnings. Case law at time, jurisdictions differ, but commingling of earnings with other funds does not necessarily defeat the ability for a head of household, head of family to trace the earnings. It's important once you find assets, and if they're commingled or if they're held tenants by the entirety, to trace where those came from. But commingling does not necessarily defeat the ability to claim the exemption. Again, notice periods are really important when it comes to garnishments and post-judgment executions and levies. The plaintiff must deny the exemption under oath within 2 business days, in Florida at least. So if an exemption's been filed, you've got to deny it with a sworn statement right away, or else you may lose the right to dispute that exemption. Just going through some other items which are exempt: prepaid college plans, health savings accounts, homestead, disability income, certain pensions and tax-exempt funds or accounts, and life insurance policies, cash surrender value of life insurance policies, and annuity contracts. So moving on to just collecting the judgment items, occasionally you'll have a defendant that will come to the table and provide you with some type of payment structure and payment plan which will want to pay on the judgment. There's just garden variety considerations that you probably need to go through. What's your client's cash position? Are they in a position where a lump sum would mean more to them? If you can do that, maybe you can negotiate something, lump sum payment for a little bit less than the judgment amount with the defendant if it's in everybody's best interest. Or, do they want their pound of flesh? Or are they going to make them pay it out over an installment period? And if they do pay it out over an installment period, what is interest doing? Is it going to continue to accrue? If they're going to pay it out over an installment period and the client wants to give them that type of grace period, or is any additional security being given? Is there any skin in the game? Is there a mortgage that can be taken? Is there an additional piece of collateral that can be taken? You want to explore those options. If you've done the legwork to find assets and you're going to give them the courtesy of not seizing those assets, you might want to pledge that as a piece of security if they default on a forbearance agreement. If it's a corporate debt and see the execution or the collection would cripple them, that may be your opportunity to get a personal guarantee if you didn't have one. You might be an opportunity to lock up a personal, get a prom note there. You just want to consider those type of options. There's the quid pro quos. If you're making a settlement of a judgment, mind you have a judgment, so there's nothing you have to settle. You have the ultimate trump card. You're negotiating against yourself only at that position. But if you're going to do that and you're going to be deferent in that respect, there's opportunities to get additional things on the table. The one key thing that I have with defendants, just keep the line of communication open. If you can't pay now, but you can pay in the future, let me know. Talk to me. Regularly stay in communication. Provide me supplemental reports on your finances. Maybe set up a reporting structure with the defendant. And it's not good enough for a defendant to tell you, I'm broke. I don't have the options of paying this. That doesn't cut it. Prove to me you're broke. Repetitively prove to me that you're broke. Show me that you're making an attempt, whatever attempt you can, to pay this down. And so be it. $50 a month. I don't care. Well, I do care. My client does care. But those are the type of good faith measures that bridges the gap for a client or for a debtor in a failing business to where maybe one day on the back end they'll be able to pay you. Key there is just being creative. Think outside of the box. So I'm going to move on now to the bankruptcy component of collections, because in this recent economy it has become a real reality. And if you do collections work, you need to know bankruptcy law. If you do most any work in civil litigation, you need to know bankruptcy law. So conceptually, bankruptcy is it's meant to give the debtor a fresh start, free from existing liens and encumbrances. There's several different chapters, whether it's Chapter 7, liquidation, Chapter 11 if it's a company and there's a confirmed plan, and then 13 there's a repayment plan, a debtor plan for individuals. The two big results, and again, the scope of this presentation is not to get into the nuances of bankruptcy law. I'm not going to drill down on those type of levels on this. I want to give you the 10,000-foot perspective and just things that you need to be aware of as a collections creditors' rights type of attorney or a professional that's moving through these matters. To really get bankruptcy, you have to know the concept. The concept is to release the debtor from personal liability on specific debts. You want to prohibit creditors from taking action. They want to prohibit creditors from taking action to collect those debts during bankruptcy. So common terms that you'll see employed are an automatic stay, which restricts the creditors from filing suit, from foreclosing on property, and all other collection methods. Discharge, which is the final release that's given to the debtor. And then the trustee. The trustee is the professional who oversees the bankruptcy actions, administers the case, collects assets, ensures the bankruptcy rules are complied with, and the liquidation's orderly. So just procedural steps. The debtor's going to file a petition. There's going to be a meeting of creditors. Of course, every bankruptcy case is different, but this is just a generic kind of overview of how bankruptcy cases evolve. Debtor files a petition. all of the key deadlines are going to be on the notice that the creditors are going to get. When you get a creditor's notice, you want to pull the petition, read the schedules, find out what assets and liabilities are there, and evaluate your motion practice at that point. There's going to be a meeting of creditors, the 341 meeting. That's your opportunity to confront the debtor, ask what creditor questions you can under oath, and often that's your time to prompt the trustee that maybe this isn't a bankruptcy case. Maybe he's hiding something, or maybe it's something that's subject to dismissal. There's going to be a period where adversarial actions are filed. Adversarial actions are initiated by the trustees. Well, mostly initiated by the trustees, but they can be initiated by either party for the purpose, a lot of times for the purposes of gaining more assets into the estate. Proofs of claim, you're going to need to know what proofs of claim are, because that's how you submit as a creditor your right to collect in the bankruptcy action. It's your sworn statement of how much is owed and a detailing of exactly what that information is in that. You have to know what a plan is. What's a 13 mean? What does it mean for when 11's filed? What are the statuses of the creditors in the respective plans? Are you secured, unsecured, priority, unsecured? Ascertain where you fall within that. There's, of course, an objection period, a confirmation period, or confirmation hearing, and then ultimately there's a discharge. So let's get into the filing a claim. And I think we've touched onto what a claim is, but it's the right to payment, whether or not it's reduced to a judgment, liquidated, unliquidated, fixed, contingent, matured, unmatured, disputed, undisputed, legal, equitable, secured, unsecured, etc. It's your rights. Whatever your rights may exist, if you think they exist, you need to file a claim and protect them. Knowing what a claim is and filing your claim is how you assert your rights. The deadline of filing a claim varies depending on the chapter that was filed, and it may be altered during the life of the pending litigation. Be mindful of the deadlines. That's critical. You don't want to miss a claims period. Debtors may object to the amount of claim, at which point, or the treatment of the claim, or even the existence of the claim. And that provides an opportunity for all parties to have a hearing as to the validity of the claim or how it would be treated in the administration of the plan. It's deemed allowed unless objected to by parties in interest. So moving on to the types of claims, and we're going to briefly touch on this, and then we'll go into, lastly, FDCPA compliance. Now, there's secured claims, and that's any claim for payment of debt that's secured by an interest in real or personal property. And there's unsecured claims, and then priority unsecured. The majority of collection, garden variety, trade creditor collection actions, they're going to be a secured claim to the extent that their judgment impairs the assets, but in all likelihood it converts to an unsecured. So you want to analyze that, and you want to file your claim appropriately. You also want to understand if there's administrative expense claims, which is administrative expense claim is the right to a claim arising after a filing in bankruptcy, and support for right of payment provides some benefits to the claim, benefits to the estate. Essentially, that's the value of goods received within 20 days of filing bankruptcy. And examples of it also are expenses to preserve the estate, or professional expenses incurred during the administration of the bankruptcy. One notion I want to touch on with bankruptcy is the stay. As to the stay, any and all action will be taken by the bankruptcy court to prevent a debtor from being harmed during the ongoing administration of the bankruptcy estate. Violation of the stay, whether willful or not, will likely result in sanctions. Severity of the sanctions depend on the level of willfulness. Sanctions are monetary or otherwise, and depending on the type of the violation. Now, if you're a secured creditor, you should consider getting relief from the stay, and the court shall grant relief from the stay for cause, such as lack of adequate protection, if their debtor does not have equity in the property and the property is not necessary for reorganization, if it's in a single asset real estate action to a creditor of the real estate, or if the bankruptcy filing was part of a scheme to delay, hinder, or defraud the creditors. Take a look at whether a stay relief might exist, and if so, move forward on the stay.
The course code is 420. The course code is 420.
Okay, so just resuming our discussion, and the last part of our seminar will be on FDCPA basics. The purpose of the FDCPA is to provide adequate laws for consumers pertaining to the collection practices of third parties. It's really to curtail abusive, deceptive, and unfair collection practices and ensure that non-abusive debtors are not unfairly disadvantaged by the unscrupulous abusive collectors, as well as promote consistent state action throughout the country, protecting consumers against these acts. The parties, I've got a slide here that says has the parties covered by the Act, but the FDCA broadly defines a debt collector as, quote, any person who uses any instrumentality or of interstate commerce or the mails in any business, the principal purpose of which is the collection of any debts, who regularly collects or attempts to collect, directly or indirectly, debts owed or due or asserted to be owed or due another. While the FDCPA generally only applies to third-party debt collectors, not internal collectors for an original creditor, some states, such as California, have similar state consumer protection laws which mirror the FDCPA and regulate the original creditors. The definitions and coverage have changed over time. The FDCPA itself contains numerous exceptions to the definition debt collector, particularly after the Financial Services Regulatory Relief Act of 2006. Attorneys originally explicitly exempted from the definition of a debt collector have been included to the extent that they meet the definition since 1986. FDCPA's definitions of consumers and debt specifically restrict the coverage of the Act to personal, family, or household transactions. Thus, debts owed by businesses or individuals for business purposes are not subject to the FDCPA. Again, I've got a slide here, a couple slides that cover parties covered by the Act and parties not covered by the Act. I'd like for you to review those as you're educating yourself on FDCPA. What I want to focus on is, at this point, the prohibited conduct and the required conduct, because I think that's going to be most helpful in the way that you garner FDCPA compliance. So the Act generally prohibits abusive and deceptive conduct when attempting to collect debts, and including the following: contacting consumers by telephone outside of the hours of 8 a.m. to 9 p.m. local time, failing to cease communication upon request. Communicating that entails communicating with customers in any way other than litigation after receiving a written notice that the consumer wishes no further communications or refuses to pay the alleged debt, with certain exceptions, including advising that the collection efforts are being terminated or that the collector intends to file a lawsuit or pursue other remedies where permitted. Again, continuing with prohibited conduct, causing a telephone to ring or engaging any person in telephone conversation repeatedly or continuously with intent to annoy, abuse, harass any person at the called number. Communicating with consumers at their place of employment after having been advised that this is an unacceptable or prohibited prohibited call by the employer. Contacting consumer known to be represented by an attorney. Continuing with prohibited conduct, communicating with a consumer after the request for validation has been made. That would entail specifically communicating, again, after that written request for verification within the 30 days period and before the debt collector mails the consumer the requested verification or their creditor's original name and address. Misrepresentation is also prohibited. Misrepresenting the debt or using the deception to collect the debt, including if you're not a licensed attorney or a law enforcement officer. Publishing the consumer's name on a bad debt list, that's prohibited. Seeking unjustified amounts, essentially amounts that are not permitted under an applicable contract or provided under applicable law. Threatening arrest or legal action that is neither not permitted or not actually contemplated is prohibited. Abusive or profane language used in the course of the communication to collect the debt is prohibited. Communications with third parties is prohibited, such as revealing or discussing the nature of the debts of the third parties other than the consumer's spouse or attorney. Collection agencies are allowed to contact neighbors or coworkers, but only to obtain location information. Disreputable agencies often harass debtors with a block party or an office party where they contact multiple neighbors or coworkers telling them that they need to reach the debtor on an urgent matter. This is absolutely prohibited by the FDCPA. Further prohibited, contacting media. Contact by embarrassing media, such as communicating with a consumer regarding debt via postcard, or using any language or symbol or other than the debt collector's address on any envelope when communicating with a consumer by use of the mail or by telegram, except the debt collector may use his or her business name if such name does not indicate that he is in the debt collection business. So the idea here is that the public shaming through the mail is a deceptive and unfair practice. And false reporting on a credit report is another prohibited conduct. So required conduct. What does that require of you? What does FDCPA require of you as a practitioner? It requires you to identify yourselves and notify the consumer in every communication that the communication is from a debt collector, and that in the initial communication that any information will be used to collect that debt. Give the name and address of the original creditor upon the written request within 30 days. That's 1692G, sometimes called a 1692G notice. Notify the consumer of their right to dispute the debt. That's in Section 805, in part or in full. Provide verification of the debt. If a consumer sends a written dispute within the 30 days of receiving the 1692G notice, then the debt collector must mail that verification, specifically in compliance with that. And it also, lastly, requires a lawsuit to be filed in the proper venue. It may only be in the place where the consumer lives or signs a contract. However, this does not necessarily restrict common law issues with respect to personal jurisdiction. So it's important to note that. I've got the mini Miranda language on here, and that must be included in the first communication. That's letting them know that any information obtained will be used to collect the debt. As a practice tip in dealing with consumer debt, just include that entire mini Miranda in all your communications. It doesn't take much effort and will save you and your client from being sued. Last thing we'll touch on with respect to the FDCPA is enforcement. Aside from administrative complaints with regulatory agencies, aggrieved consumers may file private lawsuits in state or federal court to collect damages, actual damages, statutory damages, attorney's fees, and court costs from third-party debt collectors. FDCPA is strict liability law, which means that a consumer need not prove actual damages in order to claim statutory damages up to $1,000 plus reasonable attorney's fees if the debt collector has proven to violate the FDCPA. These are often just kind of shakedown lawsuits. that are settled for the cost of defense type of things. Settlements, they're often on ticky-tack violations, so the best way to avoid these type of debtor shakedowns are through following the rules, making sure that you understand all of the parameters of the FDCPA, and making sure that you're not going to be subject to that. One thing it's important to note that you do have a mechanism to respond for unscrupulous lawsuits that you may face on FDCPA. You can escape penalty and even perhaps have counterclaims if it shows the violations was unintentional or a result of, if you're able to show that it was a result of bona fide error that occurred despite procedures and safeguards being in place to avoid the error at issue. If the lawsuit was filed in bad faith or for purposes of harassment, the court may then award attorney's fees to the debt collector. That concludes our portion on the FDCPA as well as collecting the collections law. My only parting words with respect to collections law is that collecting money is all about using it's all about persistence, being the squeaky wheel, using your creativity and your resources around you to find the assets, and being the creditor who is relentless in pursuing the debt, I think really has great benefit. Those who just get their judgment and let it rot are those who don't get paid on their judgment and waste a lot of money along the process. So thank you for being a captive audience here today, and feel free to, should you wish to email me or contact me, our website is www.jimersoncobb.com. My name is Charles Jimerson. My biography is on there. Our telephone number is 904-389-0050, and my email address is cjimerson@jimersoncobb.com when I'm in Jimerson. Thank you for your time.